thank you for your patience and for being very quiet. I'm Senator Amy Gold. I represent District 30, which is almost all of Scarborough, all of Gorham, and most of Michigan. Welcome to Labor, Commerce, Research, and Economic Development today. We'd like to begin our meetings with committee introductions, beginning with my co-chair.
Welcome. Nice to have a full room today. I'm Erin Herbig. I represent House District 97, Belfast, Northport, and Waldo.
Good morning. I'm Joel Stetkes. I represent District 105, which is the towns of Canaan, Almira, St. Albans, Heartland, Ripley, and Cambridge.
Good morning. Thank you all for coming. My name is Dylan Bates, and I represent House District 35 in Westbrook.
Good morning. Welcome. I'm State Senator John Patrick from Rumford. I represent Senate District 18, which is 29 towns and townships in western and northern Oxford County, and the town of Livermore, Livermore Falls, and Androscoggin County.
Good morning. I'm State Senator Andre Cushing. I represent District 10, which incorporates 15 communities in southern Penobscot County.
Good morning, everyone, and thank you for coming. I'm Representative Carl Ward. I represent Main House District 131, which is the towns east of Bangor from Otis down to Stockton Springs.
Good morning. I'm Representative Ryan Fecta. I represent District 11, which is part of the working people of Biddeford.
Welcome, everyone. I am representing Sue Austin. I hail from my hometown of Gray, which I represent about 7/8 of, and I have portions of Raymond, Castro, I have all of Tri-Island.
Good morning and welcome. I am Lawrence Lockman from Amherst. I represent House District 137, which is 15 towns and several townships in 3 counties. It stretches from the Penobscot Valley all the way to the Hancock and Washington County highlands.
Good morning. Welcome to the big crowd. I'm Jim Campbell. I represent District 21, which is Alfred, Chapley, Limerick, Bloomfield, and Placid.
Thank you. The purpose of the hearing is to invite testimony from members of the public regarding proposed legislation pending before the committee. The committee will hear testimony from persons present who wish to speak for, against, or neither for nor against the bills to be heard today. With leave of the chair, committee members may ask questions of any person testifying today. Other questions are not permitted. Whether or not you testify, you may submit written testimony to the committee. Please be mindful that testimony is public and is available to all once it is presented. It will be posted online. Written testimony will be distributed to committee members and will also be posted on the legislature's website for viewing by interested people. And just to advise you, this hearing is broadcast on the internet, so be mindful that the public is likely listening as well as the press. If you wish to testify, please state your name, residence, and organization you represent, if any, and sign in at the podium. Even though I know you've already signed in out at the table, and if you haven't signed in out at the table and wish to testify, you can still, I believe, go out and do that. So the way that we are going to be taking testimony today is we will hear from the sponsors, and the order we'll be going is we're going to hear LD 1351 first, and then after that we'll be going in order. So LD 404, 489, 1010, 1353, and 1319. After that, we'll be taking co-sponsors or other legislators, followed by members of the department and the administration. Designated proponents, there will be 2, one dealing exclusively with LD 1010 and one dealing with the other bills. Then designated opponents, again, there will be 2, and those won't be restricted to doing it in the same manner as the proponents are. Members of the public will have 4 minutes, as well as members of the department and the administration will also be limited in time to present their testimony, and we just also ask that legislators and co-sponsors be respectful as well of the committee's time today. I would like to introduce today, we have a guest legal analyst. Kristen Brown is here with us today for the first time, and this is her lucky day because this is a big day for the LCRED committee. And Diane Stewart is our clerk. Again, if you have testimony, please meet Diane and down at the end of the table so she doesn't have to do quite so much walking. It's also very helpful if you know that you'll be up next. We will announce who's coming up next, so it's helpful to just sort of kind of be up and ready, and maybe already have turned in your testimony so that we can keep things moving along as quickly and seamlessly as possible. Please take a moment to silence your cell phones or any other electronic devices like iPads, unless you wish to contribute to our snack and water fund, which we would be happy to accept. Also, members of the public are limited to simply drinking water in the committee room. I see some coffees around. We try to keep our committee room neat and clean. And there's also no snacking. If you do need to snack or anything, you can take it outside or downstairs. So, yes, and we may be getting up, coming and going. I know we've got a member or two here who's not feeling well today. Others may have other business around the Capitol that they have to attend to. So please don't take that as an indication of a lack of interest or concern for the subject matter. But we will be coming and going. We will be working straight through. So if committee members are hungry, I urge you to go get your food and eat in the office or bring it back here, and we'll make an exception today to allow you to eat here at the desk in the committee room so that we can just keep moving and free up everybody who's here as soon as possible. We also have an overflow room, which is energy. Okay, so anybody that's standing, if you prefer to have a seat, you can go to Energy, which is just out through the double set of doors and to the left. And feel free to sit in there. You'll be able to listen in on what's going on. So, with that, we would like to open the public hearing on LD 1351, an act to ensure that membership of public employees in unions is voluntary, presented by Representative Stepkis. 1351, Representative Stepkis, welcome.
Thank you. Good morning, Madam Chairs, Volk and Herbig. As you know, I'm Joel Stepkis. I am the state representative for District 105, the towns of Canaan, Palmyra, Heartland, St. Albans, Ripley, and Cambridge. I'm here today for LD 1351. After reviewing the other bills we will hear today, I would like to recommend that the committee votes ought not to pass, as there are other bills that have parts that closely resemble and would do a better job of representing the intent of this bill.
Thank you very much, Representative. I'm happy to entertain the motion. Representative Herbig.
Thank you, Senator. I move that we move into work session on LD 1351.
Seconded by Representative Cushing. And any discussion from committee members? Representative Austin.
Thank you, Madam Chair. Representative, thank you for helping this process move along and smoothly and speedily.
Senator Patrick.
I move ought not to pass.
Second.
So ought not to pass, seconded by Representative Cushing. Senator Cushing, sorry.
That means everything Robert made a recommendation.
Yep. Okay, any further discussion? All right, all those in favor ought not to pass on 1351. Appears to be unanimous of those present. Representative Ward? All right, very good. So, we're going to move along to LD 404, an act to prohibit public employers from acting as collection agents for labor unions, and our own Representative Lockman. Hope you had a good weekend.
I did, wasn't it wonderful?
Nice to have the sun for so many days in a row.
Good morning, Senator Volk, Representative Herbig, and fellow members of the Labor, Commerce, Research, and Economic Development Committee. I am Lawrence Lockman. I represent House District 137. I am here to present LD 404, an act to prohibit public employers from acting as collection agents for labor unions. And LD 489, an act to ensure the right to work without payment of dues or fees to a labor union as a condition of employment. I want to begin my testimony here today by sharing my personal experience as a union member and a shop steward. I was an hourly employee for 16 years at Diamond International's lumber mill in Passadumkeag. Diamond's hourly employees were represented by Local 80 of the United Paper Workers International Union in Old Town. Here is the union security language from the collective bargaining agreement between Diamond and Local 80. Quoting, Article 2, Section 1, Union Security. All new employees eligible for membership in the union shall become members on the 31st day of employment and shall maintain said membership by payment of dues. Any employee who fails to join or to maintain said membership shall be discharged by the company after written notice from the union that the employee refuses to join or to maintain said membership. All present employees will become members of the union within 30 calendar days after ratification of this agreement. Failure to do so will mean the employees will be subject to discharge in accordance with the above paragraph. Close quote. I should explain at this point that I was 25 years old when I took the job at Diamond, and I did not have a college degree, but I have been an avid reader for as long as I can remember. And it probably won't surprise any of you on this committee to learn that I've been interested in politics and public policy since I was about 10 years old. At Diamond, I was part of the organizing campaign that culminated in a successful union election at the mill in the early 1980s, because I believed that workers need to speak with one voice to management. But the more I read about labor law, the more convinced I became that the Union Security Clause went far beyond what was permitted by the law. I believed then, and I believe now, in collective bargaining. But I was very uncomfortable forcing everyone to join the union or be fired. When I raised these concerns with local union officials, my questions were greeted with annoyance bordering on hostility. I became convinced that the Union Security Clause violated workers' rights. So I filed an unfair labor practice complaint against the company and the union for including this language in the collective bargaining agreement. It took the National Labor Relations Board over a year to issue a ruling dismissing my complaint. In its ruling, the NLRB cited the language in the next paragraph of the agreement as grounds for dismissing my complaint that the company and the union were engaged in an unfair labor practice by coercing employees to join the union. Here's the quoted language they cited. The union agrees that it will not ask or require the company to lay off or discharge any employee pursuant to the union shop provisions of this agreement under circumstances which make the layoff or discharge, if put into effect, a violation of the National Labor Relations Act. Close quote. In essence, the NLRB told me that the language I just read to you negates all of the language in the two preceding paragraphs. And apparently I, as a blue-collar mill worker with no college degree, was expected to know and understand these fine points of law. Here's the simple truth. It is a violation of federal law to fire an employee for refusing to join a labor union, no matter what kind of misleading language is contained in the collective bargaining agreement. And when Mr. Schlobone from the Maine AFL-CIO delivers his testimony from this podium later today, I am certain that he will confirm that fact. So here's my question for members of this committee. How in the world would anyone other than a labor lawyer know, after reading these three paragraphs, that Diamond's hourly employees could not be required to join the union as a condition of employment? And I ask you, isn't this language, contract language, an example of union officers bullying workers into waiving their individual rights? There is only one solution to this problem. We need to adopt a state statute that makes it absolutely crystal clear that no Maine worker can be forced to join a labor union or pay union dues as a condition of employment. And we need enforcement authority at the state level to ensure compliance by labor and management. Now more than ever, it's time for Maine to join the 25 other states where workers' paychecks are protected from coerced payments to labor unions. It's called right to work. And when we pass this legislation, Maine will be the first state in New England to guarantee workplace freedom. The underlying principle is personal freedom and individual rights. Simply put, workers should not be forced to pay for something they don't want and didn't ask for. Under current Maine law, employees who have never requested union representation can be forced to accept a labor union as their exclusive bargaining agent. Then, compounding the injury, they can be forced to pay for representation they never requested and do not want. That's because federal law allows labor unions to engage in monopoly bargaining in workplaces where a simple majority of workers have requested union representation. But Maine's union bosses will never tell you that federal law does not require them to represent all workers. Labor unions are perfectly free under federal law to negotiate contracts that only set the terms and conditions of employment for their own voluntary members. But instead of exercising this perfectly legitimate option, today's union bosses consistently take advantage of the provisions of federal law that give them the tyrannical power to force every worker to submit to their monopoly representation. By exercising this power, they forbid individual workers to represent themselves. Then these same union officials turn around and complain that since they represent non-paying workers, the very same workers whose right to self-representation the union leaders just stripped away, that the union should be entitled to forced dues. Fortunately, since 1947, federal law has allowed state legislatures to right this wrong by passing a state right-to-work law. In recent years, Indiana, Michigan, and Wisconsin have joined the ranks of states that protect workers' paychecks from plundering by the big labor monopoly. Opponents of right-to-work falsely claim that allowing workers to opt out of forced dues is a race to the bottom and results in lower wages than in states that allow compulsory unionism. In fact, you can expect to hear from opponents of these bills that the sky is falling in the right-to-work states. There's only one problem with this claim. It's not true. Families in right-to-work states, on average, have several $1,000s more a year in disposable income than families in non-right-to-work states. Adjusted for cost of living, wages are better in states that protect workplace freedom. So why do entrepreneurs prefer right-to-work states? Why are manufacturing jobs moving from compulsory unionism states to states that protect workers' paychecks from union coercion? One of the reasons is that successful businesses don't want to be handcuffed by absurd and inefficient union work rules that drive up production costs. Anyone who has ever worked in or around a union shop knows exactly what kind of foolishness I'm talking about. Here are some examples of what goes on in many union shops. Laborers are not allowed to pick up 2x4s. Carpenters are not allowed to move wheelbarrows. Millwrights are not allowed to change light bulbs. And welders are forbidden to empty the trash can in their workspace while waiting for another box of welding rods. Hostess Brands was driven into bankruptcy and destroyed, in large measure because union bosses wouldn't budge on work rules that required cake and bread products to be delivered to a single retail location using 2 separate trucks. The Teamsters decreed that Twinkies and Wonder Bread couldn't ride on the same truck. Drivers weren't allowed to load their own trucks, and the workers who loaded bread weren't allowed to load cake. A sweets driver serving a 7-Eleven store was forbidden from restocking shelves with bread products already delivered and waiting in the back. He had to call for a bread driver to swing by to handle that task. Union-mandated restrictions on the company's 5,500 distribution routes nationally made it unprofitable for Hostess to serve tiny outlets. Yet the company was barred from using smaller, sleeker, and non-union distributors. 500 jobs were lost in Maine when the company shut down a little more than 2 years ago. An iconic American company that survived the Great Depression and World War II couldn't survive under the thumb of the union boss's monopoly power to dictate insane work rules. In the end, it turns out that Twinkies are easier to digest than union work rules. That is a laugh line, Representative Ward. You can let's set Maine workers free from the shackles of compulsory unionism and make our great state the first in New England to become a magnet for liberty-loving entrepreneurs and good-paying jobs. I urge you to send these bills to the House with a unanimous ought-to-pass report. That concludes my testimony today. Thank you for your attention, and I would be glad to respond to committee members' questions.
Thank you, Representative. Any questions from committee members for Representative Lockman and Senator Patrick?
Thank you, Madam Chair. Thank you once again for bringing this bill forward, Representative. As you know, I am a proud United Steelworker Local 900 member, have been for 35 years now. And your scenario of the foolishness of things that go on within the workplace, one of the things that I have seen, and I can actually concur with some of what you said probably in the 70s and 80s, but in my job, I got hired as a welder, and then I went to become a welder pipe fitter, and then in 1986, the company looked forward to trying to make some upgrades, and now I'm a welder, a pipe fitter, a tin knocker, a custodian, a laborer, and everything, because that's the right thing to do. So would you say that there are companies out there, through whatever reason may be, that total flexibility is what all companies, union and non-union, now strive for? Hearing what I explained in my mouth?
Yes. I would hope that's the case, that these highly restrictive and absurd, and as I've described them, insane work rules are a thing of the past, but the change didn't come in time to save those 500 jobs at Hostess right here in Maine.
Representative Whittaker.
Thank you, Senator. Did you work for Hostess Brands?
No.
No. What is the source of, you're making a lot of comments about Hostess Brands specific. I'm wondering what your source of information is.
There's a number of articles published about that. A lot of that was in the Wall Street Journal.
Do you think you could cite your sources and bring that to the work
absolutely.
session?
I'd be glad to bring that to the work session.
Thank you.
Any other questions for Representative Lockman? Representative Davis.
Thank you, Madam Chair. Thank you, Representative, for sharing your story. With regards to the Hostess situation, you assert in the testimony that this is a company that has been around for a very long time and survived the Great Depression and World War II and many things since that, but it's only recently under these quote-unquote union bosses' monopoly power. Do you know how long Hostess has had the Bakers Union present?
How long the
Bakers
Union represented those employees?
Correct.
I'm not familiar with the history on that.
Okay. Well, follow up on. Sorry, perhaps more directly. Do you know for how long those unions have had work rules? Was that a recent development for them, or is that something that had been in place for a long time?
I'm not familiar with the history. I know that those rules, the rules that I referred to, were imposed by the Teamsters. So you had two different unions there. I know there were something like 372 bargaining units nationally between the Bakers and the Teamsters.
Thank you.
Representative Becker?
Thank you, Madam Chair. Representative Lockman, in what year were you a member of the union? From what years?
That would be from the early 80s to the late 80s, till 1989, I believe.
I got sort of the impression that you sounded pretty progressive during those years. Was that, were your political stripes had changed, or were you just confused back then, or what's going on?
Well, thank you for that question. I would, as I said, I believed then, and I believe now in collective bargaining, but the coercion, and particularly of language, and I brought the contract with me if you'd like to take a closer look at it. The coercive language telling people, and again, these are blue-collar workers coming into a mill, and you get a contract that says, join the union or you're fired. And it turns out, no, that language is unenforceable. You don't have to join the union. So I guess I would say I've always been offended by bullies, and this is an instance of bullying.
Thank you.
Any other questions? Representative Schroeder.
Thank you, Senator. Representative Lockman, you say that in your testimony that unions forbid individual workers from representing themselves. Could you please explain that statement?
Yes. When they invoke their monopoly bargaining power, that strips workers of the right to represent themselves. Here's a hypothetical. You've got a workplace with 100 employees, and there's a union election. And the union gets 51 votes. There's 49 workers vote against unionizing. The union can then invoke its monopoly bargaining power to strip those 49 workers of their right to negotiate the terms and conditions of their own employment.
I also just have a question about if you could clarify this. It says federal law does not require them to represent all workers. That's not true. Could you explain that statement that you made?
It is true. Federal law does not require unions to represent all workers. They can negotiate contracts for their voluntary members only. And in fact, it's what's going on in Chattanooga, Tennessee right now. The United Auto Workers attempted to unionize the plant. They lost. And now they are negotiating on behalf of members of United Auto Workers.
I guess I'm just, for the work session, I think I'm just finding a lot of discrepancies in your testimony, and I'd like to really understand where you got this information from, because I'm having trouble understanding some of it. Thank you.
Representative Austin.
Thank you, Madam Chair. Representative, having been in the experiences you have explained to us in your somewhat little bit earlier career, why do you think that it would, what would the need be to, if not lawfully, but mentally perceive that you had to be a member of the union? If the union benefits are valuable and good for the worker, why this perception? Why is this necessary?
It's a good question. I'm probably not the best one to answer it, but again, if unions are offering a service that's valuable, why do you have to coerce and bludgeon people into paying for it? Another analogous situation I would use, let me pick on my good friend Senator Roger Case. He owns he's a partner in a law firm here. Can you imagine if he had an employment contract, all new employees, he tells him, as a condition of employment here, you have to join the Augusta Area Chamber of Commerce. And to make it easy for you, I'm going to withhold the money from your paycheck and send it over to the chamber. Now, people might object, say, well, that's wrong. Why as a condition of employment should I be required to pay dues to some third party? But think of it this way, too. What incentive would the local chamber have to provide good service to those employees? If the chamber is getting their dues money coerced, taken right out of their paychecks and sent over there, it's my position that they wouldn't have much incentive. And so what we're finding is that in a lot of right-to-work states, that in fact, there's some union officials actually have said they would prefer to work in right-to-work states because they have to offer something of value. In fact, I'll quote it to you here. Gary Castile, he's the Secretary-Treasurer of the United Auto Workers, said he prefers organizing in a right-to-work environment. Quote, this is something I've never understood, that people think right-to-work hurts unions. unquote. Quoting again, to me, it helps them. You don't have to belong if you don't want to. So if you go to an organizing drive, so if I go on an organizing drive, I can tell these workers, if you don't like this arrangement, you don't have to belong, versus if we get 50% of you, then all of you have to belong whether you like it or not. I don't even like the way that sounds, because it's a voluntary system, and if you don't think the system's earning its keep, then you don't have to pay, unquote. So, again, if they're offering something of value to workers, I don't know why you have to beat people over the head to make them pay for it.
Any other questions? Senator Patrick.
Thank you, Madam Chair. Representative Lockman, does the right to work have anything to do with anyone being guaranteed a job?
I'm not sure I understand your question.
Well, all these right-to-work bills are trying basically to outlaw, disband, or not allow unions.
No, they're not. That's your misperception there. It's just that you can't force anybody to join, but it would actually strengthen collective bargaining.
Is Maine an at-will state?
Yes.
And what actually is an at-will state?
You can be fired for any reason or no reason as long as it doesn't violate a host of laws on the books. So if you had voluntary unionism, say in a workplace where you got 100 employees, 51 vote to join the union, they want representation, the other 49 would not be protected by the union's grievance procedure. They would be at-will employees, but I think they ought to have that choice if that's what they want.
Any Representative Stickis?
Thank you, Madam Chair. Representative Lockman. With what you just said, when in the process of negotiations, do the unions and the businesses have the ability to negotiate the situation whether they have to represent all of the employees there, or just the ones that are their members? Do they have that ability to negotiate that?
They do have that option under federal law right now.
So under that, what you're saying is that if they truly did not want to have to represent those who were not members, they could negotiate that and make that so that they wouldn't have to.
Absolutely.
Any further questions from the committee? Yeah, Representative Herman.
Oh, thank you, Senator. I think maybe we need some clarifying information regarding what that federal law looks like.
Oh,
I
I'd be
think that's
glad.
being really misinterpreted.
I would be glad to provide that for the work session, believe me.
I'm sure we'll get into it more as we move along today. You're using some pretty aggressive language. You said coerce, bludgeon, beat people over the head to get people to join a union. Was that really your experience? Can you give me some examples of that?
Well, the coercion, all right, I'll admit the other terms are just metaphorical coercion. But it absolutely is coercion to be told, you either join the union or you're fired.
So you haven't actually seen people be beat over the head to
No.
join a union? Okay, I just wanted to clear. That hasn't been my experience, and I just wanted to make sure that was
Yeah.
not the case. Thank you.
Yeah, thank you.
Senator Patrick.
Thank you, Madam Chair. The underlying principle is of personal freedom and individual liberty. Simply put, workers should not be forced to pay for something they don't want and didn't ask for. Well, in fact, in cases of a unionized plant, someone who goes to work there, somebody like their parents or their grandparents or their great-grandparents probably could have even died trying to get the hourly wages, the working conditions, the benefits, and all that. So you think that someone should have the ability to get something for nothing?
Again, if you have to force people to pay for union representation who don't want it, people who are willing to go without the union representation, who are willing to be employees at will, who are willing to possibly be paid less or not to be part of a seniority system, I think that should be their free choice, yes.
Representative Becker.
Thank you, Madam Chair. So just so I have an understanding of the sort of historical reference you made to this time period in which you seem to fully embrace labor unions. During the 1980s, prior to you leaving in 1989, the labor union, you never made any public statements that were anti-union or condemned unions in any way.
That's a good question. I'll admit at the time when the more I read, the more I found out that this the union security clause language was coercive and it was frankly illegal. And again, I was a young man in my 30s. Yeah, it made me angry, and yeah, I probably did speak out against it at the time.
Thank you.
Representative Bates and then Senator Patrick.
Thank you, Madam Chair. Representative, I sympathize with taking a lot of questions.
Yep.
But I do want to ask if, in the case that federal law already covers the scenario, that you cannot be discharged for compulsory, or for not joining the union. I guess for lack of a better term, would this, the thing we throw around on this committee a lot, wouldn't this be a solution in search of a problem? If that's the case,
Yeah.
why is this law in state, which is superseded by federal law, why would that be necessary?
Because unless you have a right to work law, the union can still coerce payments from non-members. What the right to work law does is it makes that illegal. It makes it illegal to make it a condition of employment that you have to pay a labor union. So in the non-right to work states, you don't have to join the union. You cannot be fired for refusing to join the union, but you sure as heck can be forced to pay the union, again, for representation you don't want and didn't ask for.
Senator Patrick.
Thank you, Madam Chairman. I also did a bunch of research over the weekend, Representative, and families in the right-to-work states on average have several $1,000s more a year in disposable income than families in non-right-to-work states. The research I did, I probably would say there was an equal amount that say just the opposite. And also I saw a bunch of articles